Nilesh Tribhuvan, you believe that what the court has done is right. Aditya Pratap, you believe that it could have been done in a better way. But my question is, beyond what could have been done better or what was right, what does the law really say? Aditya Pratap, the court has gone on to say that the Juvenile Justice Board's amended order was after an outcry. Isn't that a very sweeping statement? Are we then saying the JJB from day one of hearing this entire case to day two of eventually amending the order, and the whole furor or the action that was taken eventually was completely a sham? Is that how we are supposed to see? Common people, is that how we are supposed to see?
Well, before I begin, I would like to recall a statement I had made on this channel. People say law is an ass. I say in the 21st century, law has to be a vigilant eagle. You know, there is a saying that there is a legal principle that you cannot do a fraud upon the statute. You know, you cannot cite legalese and then get away with your wrongdoings. First and foremost, when we talk about the grant of bail in 17 hours, does it happen? You know, the Juvenile Justice Act, which came out in the aftermath of Nirbhaya, it was not meant to unveil a red carpet for children in conflict with law. The purpose of a remand home.
No, Aditya, but in that case, he was given a bailable offense by the cops. So it was not like there was a case where he was given a non-bailable case. Initially, the case was under bailable. He got the bail faster or slower. That's a different point.
Exactly.
The point is, what seems to be right now is the whims and fancies. Where's the law?
See, first and foremost, exactly when the court, with utmost respect for the Honorable Bombay High Court, if the court is of the opinion that his bail was cancelled and he was taken back into juvenile court based on the remand home, based on an outcry, well, I said very logically, why did the outcry happen? The outcry happened because the accused was a rich and a powerful person, because the system was being perverted from top to bottom. So in my utmost respectful dissent, I would like to submit that merely citing an outcry is not given by whims and fancies. In this country where we have seen the Sanjeev Nanda case, we have seen Salman Khan and so many hit and run cases of rich and powerful persons. The outcry is arisen from a reason, and the court should ignore the outcry. Honorable court should have looked at the entire chain of circumstances. 17 hours the bail is being given, not even a chance to, normally at least 2-3 days lapse, chance is given to oppose the bail.
Okay. Nilesh Tribhuvan, let me come to you at this point. Now, I understand the heart of every juvenile justice board, the Juvenile Justice Act, the act under which children, accused teenagers as well, are tried, is to ensure that they are given the due course, that there is correctional measures that are taken place, and there is no undue advantage to them. But here, what we are seeing, how do you look at what the court has said? Because there are two aspects to this. One, what the police claimed. One, what the JJB, that's the Justice Board, claimed. And two, what the High Court has claimed. The three are completely different in very different dimensions. I mean, if you look at what the court has said, it's shocking. The court has said that JJB had no jurisdiction to keep the child, the teen accused in this particular case, for 25 days. So if that has happened, it's a complete travesty of justice. On the other hand, how was this child, a teenager accused, given bail in just a matter of few hours and out after he was drunken driving, speeding, landing up killing 2 people because of this accident, allegedly? This is all allegations, cases, charges that have been filed. And then you have him out on bail in no time because he's a teenager. I mean, either ways, this doesn't seem as if it's operating within the course of law.
Okay, now let me answer it one by one. So I personally disagree with Mr. Aditya, my learned friend, on 2-3 fronts. Number one, my learned friend is forgetting when the juvenile is involved in such kind of an offences, it's all solely depend on what sections our police have imposed. When he was produced before the Juvenile Justice Board, at that point of time, there was no section which was punishable lesser than, minimum punishment was lesser than 7 years. So that kind of a provision was not there. So there was no occasion for the court to even consider the aspect of treating him as a minor, as a major while granting the bail. So the court has solely followed what was there on the paper at that point of time. After that, when the court had passed an order, immediately, the public anger erupted on the newspaper, media, whatever. And thereafter, the police had filed an application for amendment of the bail application. Rather than filing a cancellation of a bail application, challenging the order before the superior court. Rather than doing so, they went before the same court, asked them to modify the order. That itself was illegal. There is no procedure in law which provides any modification of the same order. I mean, the same court cannot modify its own order. So on the very same ground, the petitioner's lawyer had approached the Bombay High Court, and the Bombay High Court had
So you're
observed
saying
exactly
what
same
the police did and eventually what the JJB acted on is illegal. That's what you're trying to explain.
Of course. The High Court also says the same thing. High Court also says the exact same thing, that the order itself is illegal. There is no authority. There was no power to keep him under the remand.
All right.
That's what the High Court is saying. And then legally speaking,